This is a lecture for my statutory interpretation and regulation class about NLRB v. Hearst Publications from 1944. And before I begin, I want to say this is a sort of a big or classic or famous case that's in virtually every administrative law casebook for upper level administrative law courses, and in most of the statutory interpretation or legislation courses. And what the case is about is unionization of people who were street vendors for newspapers in the 1940s. And so this is about a labor dispute between a publishing company and a union representing the news vendors who distribute the company's papers on Los Angeles streets. And these newspaper vendors formed a union and tried to compel the publisher to engage in collective bargaining about salary and working conditions, as employers are required to do under the National Labor Relations Act. Pictured here, by the way, is William Randolph Hearst, who was one of the wealthiest men in the country or the world at the time, and one of our early kind of mass media moguls. He owned a lot of newspapers around the country. You may have heard his name in a history course earlier in your education. He's associated with yellow journalism or inflammatory news writing, using inflammatory articles to generate sales. And he's also, at least by some people, credited with trying to start the Spanish-American War, get everybody upset so that we would go to war, to get the country out of a news slump, so that because people would buy a lot more newspapers when we were at war. And if you have visited or are from California, his personal residence is called Hearst Castle and is now a tourist attraction, and because of its lavishness. And so he was very wealthy, very powerful at the time. And Hearst refused to deal with these newspaper vendors, arguing that they were not employees within the meaning of the National Labor Relations Act. Now, also by way of background, I mentioned this on this slide. The vendors are called newsboys, and there may be a historical reason for this. In the late 19th century, in the late 1800s, children were actually used to sell newspapers, and so you may have seen old pictures of this and so forth. And actually, there was a major strike where the children organized a labor strike in 1899 that helped pave the way for child labor laws and things like that. And so at this point, we're actually not using boys, we're using grown men who would often set up a kiosk or sometimes a portable stand. Maybe they could kind of rent a closet type thing that opened out onto the street from another storefront. And so they're on basically sidewalk vendors for newspapers. And he argued that they were independent contractors according to the traditional common law test for distinguishing employees and independent contractors. So this goes to the National Labor Relations Board. And remember, this is in the 1940s. And so we're kind of at the peak or past the peak of the New Deal era. But the NLRB was a sort of centerpiece of a lot of the New Deal litigation. And part of the NLRB's purpose is to protect workers who want to unionize and who want to go on strike, and to kind of force the employer to bargain with them about salaries and wages. And what happened was the NLRB decided not to follow the strict common law definition of employee. And instead, they decided to determine whether a particular class of workers counts as employees. For NLRA purposes, one must look to the purposes of the act and the nature of the particular relationship between the workers and the firm. And so this was not merely going to look at what the original employment agreement said, or whether People had to agree that they were to call themselves independent contractors and so forth. And in this case, the NLRB concluded that the newspaper street vendors were employees within the meaning of the National Labor Relations Act. And this means that if they, the legal implication of this was that they could form a union, and if Hearst tried to fire all of them, he legally couldn't do that. Couldn't fire them for unionizing, which meant that they could kind of threaten to go on strike and force better wages. And I'm going to talk in a moment about the conditions that they had to work under. The National Labor Relations Board determined that the newsboys were employees because why? They worked continuously, regularly relied on their earnings to support themselves and their families. So these were, again, this was not like supplemental income like someone who might have a paper route today. When I was growing up, I had a paper route and delivered papers in the neighborhood. One of the afternoon local newspapers, basically to get a little bit of spending money as a adolescent. And so, but these people, this is their career, their full-time job is to run a stand like the one pictured here, or some of them were a lot less elaborate. And the publishers dictated the buying and selling prices, fixed their markets, controlled their supply of papers, supervised their work hours and effort, and gave them sales equipment for the publisher's benefit. Now, just to clarify here, so these news vendors, and I'm going to go back to the slide and show you a previous one, they could not sell the newspapers for more than the price it was printed on the front of the newspaper. And so for example, if there was a hot news day and everybody wanted a copy of the paper because, for example, the day that we declared war on Japan or something like that, or after the Pearl Harbor strike, they couldn't adjust their price upwards based on demand right then, or demand in their particular neighborhood for newspapers, nor could they negotiate for a lower rate for wholesale rate from the publisher. They had to show up at a certain time in the morning to pick up their papers, had to come back by a certain time at the end of the day to turn in their surplus papers and get a refund on the deposit they had put on those. And if they realized that their corner was a terrible place to sell newspapers because there was no pedestrian traffic, they weren't allowed to like pick up and move down the block or something like that because territories were strictly assigned. And just by way for reference for my students, I'm going to talk about this near the end, but this distinction between a true employee versus an outside contractor, like somebody, a gig worker, let's say, continues to be a hot issue in our legal system, and a big part of the traditional test, both from the common law and in light of Hearst, has been the amount of control that the boss has over the day-to-day operations. And so if the boss had just basically said, here's some newspapers and you have to pay this amount wholesale and then you can sell them for whatever you want and sell them wherever you want, then it would have been probably a different situation. But there's an awful lot of control being exercised here, what time people have to show up, what time they can leave, where they can go during the day, how much they can sell things for, and probably some of the equipment like the signage and things like that that they're using to sell their papers. Now, the Hearst matters partly for its employment law holding here, but it's in administrative law and statutory interpretation casebooks because of the distinction the Supreme Court draws between questions of law and questions of fact, and then mixed questions of law and fact. Now, in terms of standard of review, I need to remind my students, this is 1944, so we're just a few years before the passage of the Administrative Procedure Act. And in the APA, it sets forth what type of standards of review reviewing courts are supposed to use for different types of agency decisions or different types of cases that come up, depending on the enabling statute and what the agency, what type of decision the agency is making and so forth. And none of that has been codified or enacted statutorily yet, but this kind of is a precursor to that. So the court here sides with the board, but does not give what we might call modern Chevron deference or something like that, even though they end up deciding that the board is right. Instead, they say that they're doing de novo review, which means that they can completely ignore the agency's finding and start from scratch. De novo means we start from scratch, that the court can just decide for itself on the merits of the case what the right answer for the agency would have been. And so the court says, so we're going to look at the evidence that was before the agency, and we're going to engage in our own analysis, like starting from square one. But then that leads into the court trying to decide, is this a question of law or a question of fact? And before I advance in this lecture, I want my students to ask yourself, is it a factual question whether a newspaper vendor is a employee of the newspaper company, or is this a legal question? And I hope you see that you could make an argument either way, right? So maybe you could just assert it's just a fact. They are employees or they are not employees, and that's certainly what Hearst was saying. Look, it's a fact that they are not employees, and because we hired them on the premise that they are contractors, they agreed to work for us, saying that they're contractors and so forth. And so we could talk about factually, are they employees or not, but then also the question is whether under the law they should be deemed that way. So the court treats this actually, splits the difference and says this is a mixed question of law and fact. And then, even though they had said they're not deferring to the agency, now because it's a mixed question of law and fact, they decide to defer to the board's judgment on the point in light of its expertise with labor relations and its familiarity with a wide variety of employment relationships. Remember that if you want a case that this is close in time to, it's Skidmore v. Swift. Skidmore v. Swift, and we see a similar type of kind of factors being listed, like, well, okay, so this is the agency's bailiwick. This is what they have a lot of expertise, and we are kind of generalist common law judges here on the Supreme Court. And so they study all these different employment relationships. They spend all their time thinking about this. They've spent a lot of time thinking through the exact wording of their enabling statute and so forth, and they can foresee the consequences of a decision in a case. And so now I do want to back up for just a moment and notice that, or actually I have this as a second point. Hearst appears to establish a doctrinal scheme in which courts should decide pure legal questions de novo, but should defer to agencies on mixed questions. And so the court initially says, we get to decide legal questions de novo, but then because they say this is such a fact-intensive decision, that they're actually going to defer to the board after all. And so this is, when students read the Hearst decision, it can be a little confusing because the court initially says, we make the decision, we don't have to give the agency any deference. And then they all of a sudden switch and say, well, so we've made our decision, which is that we're going to give the agency deference, essentially. So why does this case matter? Why is Hearst so important? Why is it in so many law school case books as something that students are supposed to study? And why do we see later cases citing to it so much? Well, first, even though the case predated the APA, it set precedent that courts can vary the level of deference to agencies depending on the type of question that the agency decided. Later on, we really came to call this standards of review, and especially along the fact-law distinction. And this parallels in some ways, but it's not exactly like it, the deference that an appellate court gives to a trial court. So you may remember from your first year of law school that generally appellate courts will defer to the trial court's fact-finding. Why? Because they were there and got to hear the live testimony and could sense the credibility of witnesses, or who was lying or who was winging it, and who seemed reliable and knowledgeable and who seemed like a doofus at trial, and so forth. And so all of these things, you kind of had to be there. So we defer to their findings of fact, and then on questions of law for the appellate court, they say that is our job. And so we have something analogous that unfortunately uses the same type of terms when the court is reviewing an agency adjudication. And please remember, the National Labor Relations Board adjudicated this before the commissioners. So this was not a dispute about them making a rule. This was a decision in a dispute, a labor dispute between specific parties, these newspapermen and the publisher. Okay, secondly, instead of applying whatever the common law doctrine may have been in the case, the court focuses on the statute and the discretion Congress gave to the agency. And this is an important point where statutory interpretation and administrative law sort of converge. And we recognize the court is sort of evolving out of, or emerging out of, the common law era here, and saying we're now in an age of statutes. We're now in an age of statutes, and even in the past, a statute could abrogate or set aside the common law. If there was a failure in the common law doctrine, Parliament or Congress could fix that. And a classic example would be the statute of frauds from England. But now the court is saying, we have something else going on here. We have statutes that essentially entrust a lot of discretion to agency experts, to specialized agencies that are going to develop expertise on a particular area of law, of our legal system. And so they're kind of setting aside a common law approach and saying we're taking a statutory approach, which is significant for administrative law. And part of that statutory approach is we're going to look at the statute to figure out exactly what the scope of how far reaching the latitude or discretion given to the agency was, and then also to look at the statute for clues about whether the agency is really staying within congressional intent and so on. And this is a different type of thinking. This is age of statutes type thinking instead of common law. On the other hand, the common law is not dead, right? We now have court decisions and court precedent and a body of case law, evolving case law, common law, in an age of statutes. But Hearst matters in terms of our legal history because it's one of these pivot points where they're finally saying we live in an age of statutes now, and so we don't just the courts shouldn't just follow whatever the traditional common law doctrine was when we have a statute that's giving discretion to an agency. And the case also matters because of the definition of employee versus contract worker or independent contractor. And this continues to be a recurring issue in labor law. One of the current hot issues in our legal system is actually about the gig workers, Uber drivers and Lyft drivers, and people like that, and whether these gig workers, DoorDash and so forth, employees, whether they should be have workers' rights under employment statutes or not. And so this distinction, just for future reference for you, remember, Hearst is an old case now. It's not necessarily bad law, it hasn't been overturned, but it is from 1944, and we have decades and decades of employment law, case law, and new statutes and things like that. But this distinction between employee and contractor that even predated Hearst still matters, and Hearst is kind of a prism that the common law light goes through and then refracts through the different agencies and statutes that we have. So the right to unionize, and therefore the right to go on strike and without being fired, is very important, and that hinges largely on whether you're an employee. Rights to other employee benefits like health insurance or disability, workers' comp, unemployment, having a right to some sort of pension or to pay into a pension, and so forth, is very dependent on this. And so if you're an independent contractor, you are a lot of times not going to have benefits, and the benefits can be as valuable or sometimes more valuable than the wages themselves. The right to be covered under minimum wage, overtime, and to get overtime pay if you work more than 40 hours a week, and so forth. And to give a classic example, if you hire a photographer for your wedding, that's your kind of your classic independent contractor, or a plumber who comes over and to fix a clog in your sink. And so if you hire a photographer to come, you don't have to worry about calculating how many hours they were at your wedding. Did they get there early, and did they stay late and take pictures at the reception? And then make sure that whatever you're paying them comes out to more than minimum wage. If they say, look, I'll do your wedding for $100 or $1,000 or $5,000, whatever it is, that's how much you're paying them as an outside service provider. And the same is true with plumbers. You don't have to, the plumber, if it's a plumber who works for a plumbing company, they may have to pay the minimum wage. But if you're just hiring a freelance plumber or an odd job guy to come over and remove dead tree branches from your yard, or fix a leaky sink, or patch a hole in your roof, or something like that, fix your fence, you don't have to think through how many hours did they work, and am I paying them minimum wage. You just agree on a flat fee up front, usually for the service. Okay, also, which of the parties is going to pay income tax? Right, do we withhold from their wages to pay income tax and Social Security or not? And then also, it can have implications, it's not completely dispositive, but it has implications for vicarious liability for the employer. And then a parting warning. We're reaching the end of this little video, but the fact versus law distinction may seem clear in theory, but in practice it can be confusing, debatable, and it may be applied differently when courts are reviewing agency adjudications than when they are reviewing lower court verdicts.